This is an appeal in the matter of Beard and the Commissioners for His Majesty's Revenue and Customs.
Good morning, Mr. Gummy.
Good morning, my lord. Good morning, my ladies. I appear for the appellant, Mr. Alexander Beard, and my learned friend, Mr. David Yates, KC, and Ms. Calypso Blage appear for His Majesty's Revenue and Customs. Mr. Yates has taken over at short notice from Mr. Milne, KC, who represented the revenue in the Upper Tribunal, but who is unfortunately indisposed at present, and I'm sure the court would wish to send Mr. Milne his best wishes for a speedy recovery.
It does.
You have before you, my lord, a core bundle, a supplemental bundle, an authorities bundle, and a supplemental authorities bundle.
Yes.
The appeal does not concern any issue of abuse or tax avoidance. I suppose it might be said to have concerned the avoidance of Swiss withholding tax, but that was done with the agreement of the Swiss Federal Revenue authorities. And your decision will apply to all UK resident shareholders, large or small, in the company concerned, Glencore. Although it's not explicitly a test case, I understand that there are other UK resident Glencore shareholders who are awaiting your decision. And your decision will also provide guidance, I think possibly the first guidance, to any UK resident person who holds shares in a non-UK resident company that's incorporated in Jersey or indeed in another territory that adopts a similar system of company law. I'll refer to the company simply as Glencore, although as you'll see from the decisions below that it's had various names, all of which incorporated Glencore over the years. Glencore is incorporated in Jersey under the company's Jersey Law 1991 as amended. I'll refer to that in submissions as CJL 1991. And throughout the years under appeal, Glencore was domiciled in Switzerland with its head office at Bar, but it's not and never has been UK resident. The essential facts are agreed, and I'll set it out in an agreed statement, which was largely reproduced in the First Tier Tribunal decision and summarised in the Upper Tribunal decision, but the full agreed statement of facts is in the supplemental bundle at page 2. Now, in each of the 5 years from 2011 to 2012 to 2015-2016, Glencore distributed certain cash or value to its shareholders. The details of that can be found in section 3 of the agreed statement of facts, pages 10 to 14 of the supplemental bundle. And in every case, the distribution was declared to be paid out of Glencore's capital contribution reserve, in other words, the share premium that had been contributed to Glencore on the allotment of its shares, and the distribution was debited to Glencore's share premium account, which is one of its capital accounts, and no part of the distribution was debited to retained earnings. That is all a matter of agreement in the agreed statement of facts.
Well, Mr. Gammy, just to understand the descriptions there, the capital contribution reserve is not a term used in Jersey law, is it?
No, it's not. I assume that, I mean, it's referred to that.
It's a Swiss
concept. Term, yes.
Do we have, just for my interest, I suspect, accounts that show what the reserves look like on the face of the accounts?
We do, my lady. Certainly at the first tier, I think the sort of full accounts were in. There are extracts from the Glencore annual reports in the supplemental bundle.
I haven't studied them. If I look at that, will that show me a capital contribution reserve?
It will actually show you share premium, or what's described as share premium. So if you go, for example, to page 17 of the supplemental bundle, you'll see there an extract from the Glencore account, which shows on page 17, consolidated statement of changes in equity for the years ended 31st December. I think this is 31st December 2011, possibly. And you'll, yes, it's 31st. It shows the picture at 31st December 2010, and again at the 31st December 2011. And you'll see the columns where it has retained earnings, share premium, other reserves, total reserves and retained earnings, share capital, total equity attributable to equity holders, and non-controlling interests.
So that column share premium is following the labelling description in Jersey law.
It is indeed, as this is a Jersey incorporated
Thank
company.
you.
Yes, my lady. Well, and as you may have gathered, it was important to Glencore and therefore to the Glencore shareholders that the distribution should return the value contributed to Glencore on the issue of its shares, because otherwise, as a Swiss resident company, the payments would be liable to Swiss withholding tax on income dividends, which of course is ordinarily at a rate of 35%, although that might be reduced under a bilateral double taxation convention that any shareholder was able to take advantage of. And the Swiss Federal Tax Authority had agreed that no such withholding tax would be imposed on a return of the capital contribution reserve, as they called it, or share premium, contributed on the IPO. And that is in the agreed statement of facts and described the transactions, how that arrived at page, it's paragraph 1.9 of the agreed facts and issues, which is on pages 4 to 5 of the supplemental bundle. So you can see that on that page, page 4 of the supplemental bundle, the agreed statement of facts, the paragraphs 1.7 and 1.8 describe the transactions when Glencore was listed, and 1.9 describes what had been agreed with the Swiss Federal Tax Administration in relation to returns of the capital contributed on the IPO and on the listing. So as a result of that, Glencore shareholders, including Mr. Beard, has suffered no Swiss withholding tax on any of the amounts in question, including the money's worth of the distribution in specie of the Lonmin shares, which I'll describe in due course. Mr. Beard accepts, for the purposes of his appeal to this court, that the interim and final distributions that he received in cash between 2011-12 and 2015-16, although known as distributions under the CJL 1991, can correctly be described as dividends for the purposes of the UK Taxing Act that I'll come to, and I'll refer to those cash interim and final distributions therefore as the Glencore dividends. But Mr. Beard does not accept that the distribution in specie that Glencore made in 2015-16 of its 23.9% shareholding in another public company, Lonmin PLC, is correctly described as a dividend for these purposes. So I'll refer to that as the Lonmin distribution, and I'll come to that finally after I've dealt with the Glencore dividends. In Mr. Beard's submission, both the Glencore dividends and the Lonmin distribution were of a capital nature and therefore liable to capital gains tax rather than income tax. So starting with the Glencore dividends, the only issue for consideration is whether they were of a capital nature. And then in relation to the Lonmin distribution, the question is, was it a dividend so called, given the circumstances and the way in which it was returned to shareholders? And if so, was it, if it was a dividend, was it of a capital nature? Now, Mr. Beard's appeal concerns the interpretation of statutory language that was introduced by Parliament in 2005 as part of the tax law rewrite. It's not previously been used, and it reflected an intended change to the previous law, or the previous provisions. I'll say previous law because my learned friend no doubt will say it wasn't a change in the law, but it's certainly a change in the statutory provisions, as I will show you. And it has not been subject to any binding interpretive decision other than obviously the decisions of the tribunals below. Now, the principal statutory provision with which we're concerned is section 402 of the Income Tax, Trading and Other Income Act 2005, or ITOIA as it's frequently called. And that can be found in the authorities bundle at page 23. But the starting point, perhaps the right starting point, from Mr. Beard's point of view, is with section 122 of the Taxation of Chargeable Gains Act 1979, or the TCGA, which can be found on page 11 of the authorities bundle. And looking at page 11, we see section 122 of the TCGA says that where a person receives or becomes entitled to receive in respect of shares in a company any capital distribution from the company other than a new holding as defined in section 126, he shall be treated as if he had, in consideration of that capital distribution, disposed of an interest in the shares. So the return of share premium in whatever form and under any procedure provided for under the CGL 1991 will, on the face of that, give rise to a charge to capital gains tax. There's no need for the transaction to involve a disposal of the shares within the ordinary conception of disposal. It is specifically deeming the receipt to be a disposal. And even though the shareholding remains intact and unaltered in any way, as is ordinarily so in the case of the payment of a dividend, it's treated as a disposal for chargeable gains purposes. But we have to look further down in the section to subsection 5B, towards the bottom of that page 11, to see that a capital distribution means any distribution from a company, including a distribution in the course of dissolving or winding up the company in money or money's worth, except a distribution which in the hands of the recipient constitutes income for the purposes of income tax.
So, Mr. Gamming, why do you say, in the light of the words you've just read out, that the right starting point is section 122? Because the exclusion in 5B of amounts that constitute income would rather suggest to me that the right place to start is the income tax legislation.
My lady, of course, we will focus mainly on section 402, but as I said, from Mr. Beard's perspective regarding this as a capital a dividend of a capital nature, if we're talking about the Glencore dividends, if he's looking for where he's going to be taxed in respect of it, it's under section 122. And of course, I just want to make the point, essentially a preliminary point, that you don't actually have to have a disposal of the shares to fit within that. And
so I take it as uncontroversial that these distributions are subject to capital gains tax.
That is admitted.
They're not subject to income tax.
Indeed, my lady, that is admitted. And
would they be subject to CGT under section 122?
Under 122,
right.
Yes.
So the essential question statutorily is it 122 or is it 402?
Indeed, my lord. I just wanted to show you.
No, I quite understand, but in a sense they're partner provisions, and you say you fall into one of them, and they say you fall into the other.
Indeed, my lord. Indeed, my lord. And the only other point I was going to make, in a sense by way of preliminary, was just to say it's also recognised and accepted that the Lonmin distribution, in other words, the distribution in specie of the Lonmin shares, was not within section 126. So it's not a new holding as defined in section 126. So it's not that the Lonmin distribution falls out outside 122 because of that. So as you correctly said, my lady, our focus is going to be very much on the income tax provision, section 402, and that is at page 23 of the authorities bundle. And it's actually very short and sweet, if you like, for tax legislation. Not too much difficulty here. Section 402, subsection 1, tells you that income tax is charged on dividends of a non-UK resident company. Subsection 4 tells you that in this chapter, dividends does not include dividends of a capital nature. So the 2005 Act explicitly recognises the possibility that a payment by a non-UK resident company may not be taxed as a receipt of income by a UK resident shareholder, notwithstanding that it's returned in the form of a dividend, something that counts as a dividend. And the characterisation in that case of the shareholder's receipt as a dividend is therefore not determinative of its character as income or its liability to income tax, rather than the capital gains tax provisions that we've seen. And I think possibly quite unusually for a tax appeal, we're not now going to have to delve into too much interstices of legislation. I'm not going to promise to avoid all legislation, but it's, as we can see, it's a relatively straightforward provision that we're dealing with. Now, as I said, the Section 402 and ITOIA as a whole is a product of the tax law rewrite. And one of the aims of that was to rewrite the UK's primary direct tax legislation, income tax and capital gains tax and income tax and corporation tax, to make it clearer and easier to use without changing the law except in ways that were identified in advance. There have been a variety of authorities on the interpretation of tax law rewrite provisions, which were not, were obviously referred to below. I didn't actually feel it was necessary to include them in the bundle of authorities here on the basis that I don't think there's anything controversial about what they say. Obviously, there is something more controversial about what their effect is, which we'll come on to. But as has been pointed out by Justice Sales in a case called Eclipse Film Partners number 35 LLP, in which I had the privilege of representing His Majesty's Revenue and Customs, the tax law rewrite acts are not consolidation statutes as such. In fact, Parliament adopted a separate procedure for the enactment of the tax law rewrite legislation in place of the ordinary procedure applicable to consolidation acts, and the principles, as I say, to be applied in the interpretation of the rewrite legislation have been considered on a number of occasions, the first main one being by Mr. Justice Sales, as he then was in the Upper Tribunal in Eclipse Film Partners number 35. Now, those authorities are now in the supplemental bundle of authorities, and I'm happy to take you to them if you would like me to, but I think it's really a matter of just reading what was said there in the supplemental bundle of authorities. Eclipse Film Partners is is the first one starting on page 2, and the relevant passage can be found in the supplemental bundle, pages 35 to 36. And you'll see on page 35 that it's marked starting at paragraph 95 of Ms. Justice Sale's decision. The point in Eclipse was that there was a specific provision that had been introduced into the ITOIA, which had no previous precedent in the legislation that was being rewritten. So it was, in a sense, it was rather similar to what we had now, in that the original provisions were under Schedule D of the 1988 Income and Corporation Taxes Act. When it was rewritten, a new section 609 was introduced, which had previously, if it had fallen anywhere, it would have fallen under the miscellaneous income category of the Income and Corporation Taxes Act, but there was no specific charge on what was covered, no explicit charge that was covered by section 609. So, of course, the argument for the taxpayer in Eclipse 35 was, well, you have to look back to the old Schedule D cases and decide, whether or not would it have fallen in the miscellaneous income provision, or was this something that always fell within the trading provisions of the Income and Corporation Taxes Act? To which question was, well, what did section 609 do? And yet, as I say, I'm content, I think, to leave you, unless you want me to take you to it, to read what Mr. Justice Sales said in Eclipse. The only point I'd note is that on page 35, in paragraph 97, at the bottom of that page, starting with the sentence, when construing a consolidating statute, going over the page to the end of the sentence on the 4th line, where it says disparate provisions and construe them, that particular passage of what Justice Sales said was subsequently approved by the Supreme Court in a case by Lord Carnworth in a case called Derry, which is the second case in the Supplemental Authorities Bundle, and you can see that on page 47.
Just before we leave Eclipse, I think one of the things discussed in Eclipse was the fact that, slightly earlier on, is the fact that the notes to the explanatory notes to these two, ITOIA and the subsequent tactful rewrite statutes, say we're reenacting with minor changes. And there's some discussion, I think, in Eclipse of whether the relevant item was listed as one of those minor changes. I'm not sure we've got all the relevant parts of the explanatory notes in the bundle, but I did have a look at the entire explanatory notes, which do not list section 402 as including any of those identified minor changes that are set out in Annex 1.
Yes.
I can't recall exactly what the discussion was in Eclipse at that point, but I can see it was discussed.
My lady,
Anyway,
I
can see
can't
there's some
off the top
discussion
of my
about
head recall whether that particular point was discussed or not.
But it may be of some relevance, because as you say, you rightly say that ITOIA was intended to rewrite the legislation in a clearer way, but not, I think you said, not to make changes except in ways identified in advance. You are, at the core of your submission in this case is that there was indeed a change made by section 402, and I don't think it was identified in advance if it was a change.
Well, my lady, in a minute or two, I'll take you to the explanatory notes and what they say.
Just in case it's of any interest. Paragraph 87 to 89 seem to be the passages in Eclipse which deal with minor changes.
Thank you, my lord. I think the point, well, I'll come on and make the, as I say, I'll take you to the explanatory notes, but I think, of course, the point about foreign income was that there was, when I say there was a major change in the structure of things, because previously, as I'll show you, foreign income was charged separately in the sense that it fell within what was Schedule D, Case 5, income from foreign possessions. And one of the explicit changes to the rewrite was to integrate foreign and UK income and charge it by reference to its type. So that, in other words, what type of income it is. And I'll show you that as I go through. But it may be, my lady, I can't answer your specific question off the top of my head about, you know, where it was in the notes and so on. But of course, it's within a section of the Act which is being restructured in any way.
Indeed. I think, I mean, I just wanted to put to you, because I have checked, and
Yes.
others may wish to check and correct me if I've got this wrong. I cannot find any reference in Annex 1, which is the express list of minor changes, cross-referred to right at the beginning of the explanatory notes, to section 402, including any change.
Yes, my lady, I also did look when I came on this case. I think my reading time has been about the same as yours.
Yeah.
And I've checked both the explanatory notes to the bill as well as the explanatory notes to the Act as published.
Yes, and that's relevant as well.
And there is no change listed for 402. There are changes made elsewhere to the dividend code, particularly the UK dividend code.
Quite different.
So the nearest change, because it's always listed in terms of the order of the sections, is change 84. We obviously did not put in the entirety of the annex to prove a negative, to show that nothing is there, but we, if it would assist, we could maybe bring changes 84 to 85 and you can see the absence of a change.
I think it would be helpful, speaking for myself, to have that background, because it seems to me potentially relevant.
Indeed.
Well, my lady, I'm sure I'm more than happy to take my learned friend's word for he's checked it, and as I say, the point is, and as I say, you'll see this from the explanatory notes on section 402. The point is that this was an area of the Act that was being restructured, and there was a particular reason why the, if you like, UK distributions were within Chapter 3, UK corporate distributions within Chapter 3, and non-resident company distributions were in Chapter 4. But we'll get to that. I think for the present purposes, as I say, unless you particularly want me to take you through the cases that are in the supplemental bundle on this subject, I'm more than happy to leave them to be read, because I mean, they just provide indications about how to approach the interpretation. But of course, what we are concerned with is the statutory language as it exists, and that is what we have to, or what you, my lady, my lord, have to interpret. So the three cases, as I say, there's Eclipse Film Partners number 35, it's Justice Sales, there's the Supreme Court, and particularly Lord Carnworth in Derry. His comments are at pages 47 to 48 of the Supplemental Authorities Bundle, and then there is also Lady Arden's comments in Derry, there at page 67 to 68 of the supplemental authorities, and finally Lady Arden's particular comments, which related to how much previous case law might or might not be relevant to the interpretation of a tax law rewrite act, were commented on in NCL Investments Limited, which is the third case in the supplemental authorities bundle, and the relevant comments are at page 83 to 84 of the supplemental authorities bundle. So those are the comments that are particular comments to be made in relation to the tax law rewrite legislation. Now, one of the acknowledged changes to the tax law rewrite project made to the previous law was to dispense with the system of charging tax under the various schedules and cases, as had been the practice since income tax was introduced. Certainly, I can go back to Addington's Act of 1803, but Sir Robert Peel's reenactment of the income tax in 1842. So that's how it had always been. And to an extent, the abandonment of schedules and cases is more evident than real, given the approach to the way in which income is categorised under ITOIA. But in the case of foreign income, the change was real in the sense that it had previously been charged under a separate heading, in particular Schedule D Case 5 that we'll come on to, but now it was integrated with the other types of income, and ITOIA then specified types of income, whether UK or foreign, and then charged that type of income to tax. So in the case of Section 402, as we see, it's charging to tax dividends.
So when you say integrated with the UK, with the charge on UK income, that may well be the case in relation to certain types of income, but is it? Can you really say that in relation to foreign dividend income? Because the charging scope and process under Chapter 3 UK distributions, yes, and Chapter 4 foreign dividends is completely different.
Indeed, my lady, and there's a very specific reason for that, and we'll see that explained in the explanatory notes as to why that is so. It's always been the case that dividends from UK resident companies, they may be incorporated elsewhere, but if they're resident in the UK, they fall under one heading. Whereas if they're non-resident, and of course originally that could include a UK incorporated company that was non-resident, since 1988, UK incorporated companies, the general rule has been that they are UK resident for tax purposes, but originally they needn't be. That they have been charged, amounts returned to shareholders have been charged differently according to whether or not the company, wherever incorporated originally, was resident or not. And I deal with that to some extent in my skeleton argument, or explain some of that in my skeleton argument, because the point was originally, to put it in, if I can put it in sort of slightly simple terms, UK resident companies were effectively transparent, so that the point was they were taxed on their profits, but a shareholder wasn't taxed on a distribution of their assets because it had borne tax. It was coming from a taxed fund, the taxed fund being the company. Whereas, of course, if it was a non-resident company, the UK had not necessarily taxed the fund from which the dividends were paid, so a different approach was applied. That's the origins of it, and it's to the extent that you want to see any authority which explains that origin. It's in a case called, or one of the cases, there's a whole raft of cases that one could refer to, but the case that we have in the authorities bundle is a case called Bradbury versus the English Sewing Cotton Company, which is at page 343 of the authorities bundle. And if you look at that, you'll see it explained why the location of the company is not based on just on its incorporation, it's based on where it is resident for tax purposes. And so the two were treated differently. But just going back to the tax law rewrite and the changes that it made, for most purposes, it abandoned the idea of taxing foreign income separately from UK income. It integrated the two and charged that type of income to tax, but it preserved the distinction that existed between UK and foreign income by restricting the charge to income tax on non-UK resident individuals to their UK source income, and in the case of UK resident but non-domiciled individuals, by identifying something called relevant foreign income in Part 8 of ITOIA to preserve the remittance basis of assessment for those individuals. So you have quite a lot of change, certainly structural change in ITOIA. The move to taxing income by reference to its type of income, and then having specific provisions scattered across the Act to distinguish between UK resident and non-resident individuals and what element of that type of income they were actually taxed in respect of. So quite a lot of structural change. Broadly speaking, foreign income was originally, as I've said, charged to tax separately under Case 4 covered foreign securities and Case 5 foreign possessions, and both of Schedule D, and to some extent under Schedule C in the case of public revenue dividends payable in the UK. In other words, dividends within that categorisation of public revenue dividends, even though paid possibly by some public authority outside the UK, but payable in the UK. So it could include overseas public revenue dividends, even though, because they were being paid through UK paying agents. Now, to see these original provisions, just very briefly, we can go to page 4 of the authorities bundle to see the original provisions of the Income and Corporation Taxes Act. Section 1.1, subsection 1 tells us that income tax shall be charged in accordance with the provisions of the Income Tax Act in respect of all property, profits or gains respectively described or comprised in Schedules A, B, C, D, E and F set out in sections 15 to 20, or which in accordance with the Income Tax Act are to be brought into charge to tax under any of those schedules or otherwise. So that's the basic charge. And the charge under Case 5 arises under Schedule D on Section 18. Just going on page 5, we can see Schedule C as it existed in 1988, which covered public revenue dividends payable in the United Kingdom. But Section 18 comes below that. As we see at the bottom of page 5, the schedule referred to as Schedule D is as follows. Tax under this schedule should be charged in respect to the annual profits or gains arising or accruing. And then it lists 3 sub-paragraphs. So anybody residing in the United Kingdom for any kind of property whatsoever, whether situated in the United Kingdom or elsewhere, any person residing in the United Kingdom from any trade, profession or vocation carried on in the United Kingdom or elsewhere, and then to any person, whether a Commonwealth citizen or not, etc. And then B, all interest of money, annuities and other annual profits or gains not charged under Schedule A, B, C or E and not specifically exempted from tax. So you can...
The point, Danny, is that the rewrite changed the structure of the way in which these matters were taxed.
Indeed, my lady, you can see though in B, so section 18(1)(b),
Yes.
that it is identifying specific types of income, interest of money, annuities and other annual profits or gains. And in relation to the earlier parts, A, it's just charging tax in respect of what is derived from possessions, so what is income derived from possessions, and the way in which the ITOIA changes it is to identify specific types of income. And in relation to foreign income, we see that under Schedule D, the tax is charged under the cases set out in subsection 3. The cases are there, and we can see that case 4 and 5 are at the bottom of page 6. So it's tax in respect of income arising from possessions out of the United Kingdom, not being income consisting of emoluments of any office or employment.
I mean, your point, among others, is that possessions was obviously much wider than covering foreign shares, for example.
Indeed.
Whereas the approach under ITOIA is to look in a more granular way at the different categories
Indeed.
of income.
Different types of income.
And we are now concerned with Section 402.
We're now concerned with the type of income that is a dividend, that falls within dividend. And you're absolutely right about possessions, because the first case to consider possessions was a case called Colquhoun and Brooks, which was all about Mr. Brooks's interest in a Melbourne partnership and whether it was a possession, his partnership interest, and if so, was it a possession, a UK possession or a foreign possession? So yes, possession is, broadly speaking, anything you can possess and a bit more, possibly, if you read some bits of Colquhoun and Brooks. So that was the law as it stood before the rewrite, and in current terms, the possession that is being referred to, that's relevant to us, are the shares in respect of which the dividend is paid, and that is clear from a case called Reed's Trustees, which I'll take you to a bit more as we go, which is in the authorities bundle at page 397, and in particular, I think it's at page 407. The point is made, 407 for the authorities bundle. The point is made that possession for case 5 purposes is the shares in respect of which the payment is received. But as I say, Section 402 explicitly recognises that the charge to tax under Chapter 4 now depends on the character of the receipt as dividends of a non-UK resident company. In other words, the receipt must have been paid by a non-UK resident company, such as Glencore, and must have the character of being a dividend. And of course, as I've already mentioned briefly, somewhat similarly, tax under Schedule C was originally expressed to be charged in respect of all profits arising from interest, annuities, dividends and shares of annuities payable out of public revenue, the concept being that the payment should be of a recognised character and come from the public revenue, just as under Section 402, the payment must come from a non-UK resident company. And of course, Schedule C in the meaning of public revenue dividends was one of the issues in a case called SO Petroleum, which is in the bundle at page 472, which we may come on to in due course. So in this respect, there is no requirement in section 402 to identify a foreign possession from which the receipt is derived, in respect of which it can be said that receipt is income of that possession. All you need to be able to identify is a non-resident company, non-UK resident company, and a receipt that can properly be classified as a dividend. Of course, the essence of a dividend is that it leaves the corpus of the share intact. That was what was said on one of the main points that was made in a case, in the Reed trustee case. And we can look at the various bits. They're mainly sidelined in the Reed trustee case. As I say, case is in the authorities bundle starting at 397, and if we just go through the case from there, you'll see other parts have been sidelined for your attention. So as I said, on page 407 of the bundle, the claims made on case 5 of Schedule D. They say the sum is income arising from possessions out of the United Kingdom. The appellants in this case, of course, are the Inland Revenue. So it's the revenue saying this is income arising from possessions out of the United Kingdom. The shares in the South African company are possessions out of the United Kingdom, and the sum in question is income arising from those shares. They say there's no tertium quid. The sum is either capital or income. How can it be capital if the shares remain intact? So many shares of £10 each in the capital of the company. There is a way of distributing a dividend while leaving the capital intact, and there is a way of returning part of the capital. It is the former course that has been taken. This then, they say, is income, and just further down that page you see that Lord Simmons says, "My lords, this is a short and simple case made by the appellants, and I see no answer to it." And then here we can just go on to and we see a passage on page 409 which has been sidelined. It's not be taken as suggesting any inaccuracy or insufficiency in the information that has been furnished by the South African company. It is obvious that as a general rule, the Inland Revenue authorities cannot have the same facilities for investigating the affairs of a foreign company and checking its statement the dividend is paid out of capital profits. They must work upon a broader basis, and I cannot imagine a safer or better one, where the question is as to income arising from a foreign possession than to ask whether the corpus of the asset remains intact in the hands of the taxpayer. That question can, in the case of shares here in question, only be answered in the affirmative. The shares the respondents held before the distribution of the dividend they still hold intact. The dividend they received was income arising out of those shares. So that's obviously saying, well, a dividend ordinarily leaves the shares intact. So that must characterize it as income. But of course here we're dealing, section 402 is specifically requesting us to identify a dividend of a capital nature, and therefore the fact that they leave the shares intact cannot be conclusive in my submission that it's not of a capital nature. On page 400.
Sorry, I didn't follow that. If you could just expand upon it, I'd be grateful. Section 402 is looking for a dividend from a non-UK resident company, but doesn't include dividend of a capital nature. But you said something in relation to the corpus test, which was being used in Reed. And if you just reiterate how those things interact as far as you're concerned.
Well, insofar as these cases are dealing with the old law and in dealing with a system of company law, which is assumed to be the same as English law, a dividend ordinarily leaves the shares intact in the sense that you've got here in this case, a £10 share and a dividend's paid in respect of it. It remains a £10 share afterwards.
Yes.
And therefore, to the extent that what we're looking at under section 402 is something which has the character of a dividend, but where you've got to ask, is it of a capital nature, then the fact that the share in respect of which the dividend is received remains intact, in my submission, cannot be conclusive that the dividend is not of a capital nature, because you're having to ask yourself the question, here is a dividend which ordinarily leaves a share intact, is it of a capital nature? So the sorts of things that are being looked at Reed and determining whether or not something is or is not a payment of income because it leaves the share intact can't be quite the same when one's looking at section 402 in my submission, because if it is correct that a dividend leaves the share intact, how can it ever be of a capital nature?
Well, yes, that's the core of the point. I
Indeed.
think you're making the point, Mr. Gammy, that section 402 uses the word dividend, but anticipates that you can have something which is a dividend of a capital nature.
Indeed.
Now, that is perhaps very hard to conceive of under a system like UK company law.
Indeed.
And indeed in Reed's trustees, as I recall, there is no separate consideration of foreign law. I think it must be assumed that South African law is the same.
That is correct, my lady.
English law. But we do have other cases in the bundle. One I alighted on was Courtault's case, where there is description, or at least some description in the case, of what was paid by an Italian company as being a dividend, yet Mr. Justice Buckley found that was capital. Now that was under a very different system of company law.
Yeah, indeed, my lady. I don't think I'm going. When I say not going to disagree with that,
But,
you're absolutely, my lady. If I can just, Lord Justice Moses in the First Nationwide case said that the payment in Courtauld was not a dividend. It had been incorrectly described in the head note, I think, to the weekly law reports as a dividend, but in fact it was a repayment of the capital.
Well, you can take us to that. I think there may be some reference in the judgment as well. But I think what I'm trying to understand a bit better is why you say that it must follow that the test of whether the asset is left intact cannot now be conclusive.
No, my lady, sorry. Well, I'm, my apologies if I'm, of course, come on, of course, that may be a consideration. I'm not saying that, you throw that out of the window entirely. It may be a consideration, but I'm saying it cannot be determinative. Because if the basic idea is that, certainly as a matter of our law, a dividend leaves the shares intact, it must be contemplating a system of a foreign system which is different, which may leave the shares intact, but which nevertheless can be identified as giving rise to a payment of a capital nature. And as my submission is that when you look at matters, in particular when you look at the Jersey law, a payment of share premium or a return of the amount that has been contributed for the shares on their issue is the archetypal type of payment of a capital nature. It has always been recognised, as I'll point out, under the UK tax system, that you do not tax as income a return of share premium. Even before the time at which it was not possible to pay a dividend of share premium, so before 1948, a dividend of share premium was not taxed as income. It was capital.
Could I just understand how you situate the argument in relation to corpus,
Yes.
as you put it, being something to be considered but not conclusive? Is that an argument which depends upon Section 402 and the new state of affairs? Are you saying that because of?
It arises from how you determine whether something has a
That's the
capital
402,
nature.
the 402 question.
Yes.
Yes. So, I mean, take for example, I mean, in a counterfactual, that that 402 hadn't been enacted and we were still under the law as it was being considered in Reed's trustees. That argument wouldn't be open to you. Is that the point, that 402 changed the situation?
In relation to a non-UK resident company, I think that's based on Reed's trustees. That would be, well, when I say that would be correct, it would be a moot point. There was the only authority that we have in relation to the payment of a dividend by a non-resident company out of share premium is First Nationwide. And as I will point out, the Cayman Islands law in First Nationwide is not the same as the Jersey company law. So broadly speaking, before, under case 5, we had no absolute authority as to how a payment of share premium contributed on the issue of shares was to be treated. We have an indication. There is a case called Osmond in the authorities, which again I'll come to, which is dealing with our anti-avoidance provisions for what are known as transactions in securities. I'm going a little bit, maybe easier if I explain that when I get to it.
Yes,
But
well,
I think
I
the
just
simple
wanted
answer is there is
to
no
understand the
authority.
degree to which your argument depended upon the fact that things had changed, because to my untutored eye, if we were applying obviously the corpus test as described by Lord Simmons, then that seems to be difficult for you in this case. And I wanted to understand whether you were in effect saying that was how matters stood, but they don't stand that way any longer.
Well, no, well, my lord, no, I don't say it's difficult, because ultimately you've got to go to the foreign law and look at what the foreign law, what is the nature of the possession, and how does the foreign law characterise what is being returned to help you answer these questions. And the only authority that deals with share premium is First Nationwide, where the revenue we're arguing, I was arguing for the revenue, that the dividend in First Nationwide was a dividend of a capital nature. That was the revenue's argument, in essence, in First Nationwide.
Oh yes, but it wasn't under Section 4. It wasn't an argument under Section.
No, but it was no. My lady, I'm sorry. I was responding to your Justice's question about where this situates for the corpus. It was a case which was under case 5. So it did involve questions as to corpus. It did involve questions as to corpus. Necessarily, because that was the possession in First Nationwide was a set of preference shares where the whole of the capital whole of the share premium contributed was paid out as a dividend, and the capital rights attaching to the shares diminished as the dividend was paid. So the whole question in First Nationwide, the revenue said this was a dividend of a capital nature, and we'll see why that was decided against the revenue in that case, but which I say do not apply in the case of Jersey. In other words, if the Cayman law had been the same as the Jersey law, I would say that the decision in First Nationwide would have gone in favour of the revenue rather than against it.
But just to step back again, I think I hope to clarify my Lord Justice Peter Jackson's point, and it's my point too. You're saying we need to look at the relevant foreign law, in this case Jersey law, in order to see how the, I hesitate to use the word distribution or dividend, whatever, how the payment is characterised under that law. But then you say, and you did say, the corpus test might be a consideration. Now, is it or isn't it, in the sense that we're to look at how Jersey law characterises this, and therefore that corpus may or may not be a way in which a window through which Jersey law considers this or not. It is dependent, is this your actual submission? It's dependent entirely on how it's characterised in Jersey law.
Yes, my lady, I will take you to, how foreign law fits into the picture here. The question that you're being asked to answer is this dividend? We're looking at the Glencore dividends. They're accepted to be dividends. Are they of a capital nature? Now, obviously, in answering that question as a matter of UK tax law, the corpus may be a consideration that tells you that this is of a capital nature. All I say is corpus is not finally determinative. In other words, that's not the only test that applies to determine whether or not something is of a capital nature.
So you look at Jersey law, see how they characterise it, and then consider, as a matter of UK tax law, how that fits in.
Indeed, my lady.
Okay.
Indeed, my lady. That's absolutely correct. So I don't know whether you want me to. I won't necessarily detain you any longer on what was said in Reed's Trustees. I'm not. The passages are there and highlighted for you to read. I'm not, when I say abandoning those of what's said there. I mean, but that was just to provide you with an explanation of how the law worked under Case 5 and how it was approached by the courts under Case 5. And the two other main authorities in this particular area, other than First Nationwide, are Ray and Lazard's Investment and Courtaulds, in neither of which was the payment a dividend. It was a return of the capital that had been contributed. Well, in the case of Ray and Lazard, it was what was called a partial liquidation, so it was effectively a demerger. of a larger entity into two. And in Courtaulds, it was effectively a return of part of the capital that had been contributed for the shares. It was share premium, but it wasn't paid as a dividend. The point about Courtaulds was that it was a very neat trick. Oh, maybe that's the wrong word. It was a very neat transaction suggested by a shareholder, I believe, specifically to avoid an Italian withholding tax on dividends, just as in this particular case, the Glencore dividends are being paid in a particular way to avoid the Swiss withholding tax. So what they did was to transfer the earnings, the distributable earnings, into a reserve, and that allowed them to return part of the share premium to the shareholders, which was not a dividend as such, but was of a capital nature in my submission. And I say that's precisely what we're looking at. In many ways, with Glencore, they didn't want to suffer, and their shareholders quite obviously would not want to suffer a 35% withholding tax in Switzerland. I mean, as a publicly listed company, it would make the company's shares, untradeable in many respects for many people if it was going to suffer a 35% withholding in Switzerland. So broadly speaking, they kept their earnings and they returned the share premium that had been contributed on the issue of the shares. And the question is whether, just as in Courtaulds, that the Courtaulds return of the share premium in Courtaulds was of a capital nature. In exactly the same way, the question is are the Glencore dividends as a return of the share premium on the issue of shares of a capital nature? It's the same question. So, as I say, turning away from Reed's trustees, which Reed's trustees explained in my skeleton argument. I'll tell you where it's dealt with in the skeleton, which is in the core bundle, and it's in particular dealt with at, starting at paragraph 49 in the core bundle, page 33 through to 35, where I start to deal with First Nationwide. So that section of my skeleton argument talks about the taxation of foreign dividends before Itoya. So as I said, the charge to income tax depends upon the character of the receipt as a dividend in much the same way as, for example, the charge to income tax on interest depends upon the character of the receipt being an amount paid by reference to time for the use of money. And whilst the nature of interest is always income, Itoya now recognises that a dividend need not be if it's capital in nature. Now, the explanatory notes to Itoya, which, when I say deal with this, or they explain the change being made, can be found in the authorities bundle at page 959. And we see there, these are the explanatory notes to the bill. So this is the explanatory notes to what Parliament's being asked to enact. Paragraph 184, this chapter introduces a separate charge to income tax on dividends from companies not resident in the United Kingdom. Under section 18.3 of ICTA, there are no individual charges according to types of income within Schedule D, Case 4 or 5 charge. the systems of identifying and classifying income by schedule and case has been replaced in this bill by individual charges on types of income. Precisely my point, types of income here, dividends. And then we see at 186, income which under the source legislation is charged tax under Schedule D cases 4 and 4.5 has, where appropriate, been fully integrated with the equivalent income arising from a UK source, as I explained. In the case of dividends from non-UK resident companies, there's no exact equivalent in terms of UK source income. The closest equivalent is the charge to tax on dividends and other distributions from UK resident companies, Section 20 of ICTA Schedule F in the source legislation. But there is no precise overlap. The UK charge, by the adoption of the definition of distribution from Part 6 of ICTA, see the commentary on Chapters 3 of Part 4 of the bill, can include dividends or distributions of a capital nature and can also operate to convert payments that would otherwise be treated as interest into distributions. Any charge on distributions from non-UK resident companies must be confined to income only. For this reason, it's not possible to integrate the charge, and a separate charge is needed to cover dividends from non-UK resident companies. Now, just pausing there, it's plainly that the charge under Chapter 4 on non-UK resident companies does not include dividends of a capital nature. And from that, from what it said in paragraph 186, one might discern that Parliament's not being asked to extend Chapter 4 to what Chapter 3 would treat as a distribution, but which is of a capital nature. In other words, there are certain things under Chapter 3 in the definition of a distribution in Part 6 of ICTA, which continued to apply from ITOIA. If I can just go slightly off on a tangent, Part 6 of ICTA contained the definition of a distribution for a UK resident company. That remained in place after the enactment of ITOIA. In other words, it was not part of this bit of the rewrite. It was only rewritten in the Corporation Tax Act 2010. So between 2005 and 2010, the definition of distribution in Part 6 of ICTA continued to apply for the purposes of defining distributions from UK resident companies. And it was then replaced by Part 23 of the Corporation Tax Act 2010. Now, we're not directly concerned with the definition of a distribution for a UK resident company because we're obviously looking at a non-UK resident company, but as Section 186 says, there are certain things in the definition of a distribution for UK resident companies which are of a capital nature but which are charged to tax on a UK resident company but are not charged to tax in the case of a non-resident company because that doesn't include dividends of a capital nature.
I'm not really sure how far this takes us. I mean, it's clear on the wording of the legislation that dividends of a capital nature are excluded from the charge under Section 402. I don't think we've got Part 23 or in the bundle, and
We do.
not everyone in court might be aware that it's a very complicated set of rules. I'm not really sure it's helpful to well, it's not before us, and I'm not really sure it assists us.
Well, my lady, it is in the bundle. It's at tab 5 of the authorities bundle, Corporation Tax Act 2010, part 23, for the year 2012-2013, which of course is one of the years when Mr. So it is there, but I just have a simple point to make in relation to it.
So I would just caution, it's a very complicated set of rules.
Indeed,
as
my
those
lady.
who've had to look at it will know.
Absolutely, absolutely. I always shudder when I'm asked to have to get into the weeds of part 23 or before it, part 6. But I have a very simple point to make in respect of it. The one thing that it does not charge is a return of share premium to a UK resident company. Now, if what the draftsman or the person who wrote the explanatory note is telling to Parliament is that there are certain things that are of a capital nature, but which are charged on UK resident companies as distributions, but we don't want that to apply to non-resident companies. If there is something that is not charged as a distribution anyway, because it's capital, why would that be covered? Why would that not be also of a capital nature? In other words, part 6 and subsequently part 23 take out of charge the return of share premium for a UK resident company. Why would it come into a dividend of share premium in chapter 4 when the reason why it's not charged under as a distribution is because of its a capital nature? It doesn't
Mr. Gammy, if you're making the point that a UK resident company making a distribution from share premium account would make a distribution that was capital in the hands of the recipient, and I think that's the point you're making. I'm not sure I would agree that part 23 would have that effect. I mean, this is the danger of looking at part 23. It on its terms covers capital dividends. That's what, if you look at it,
well,
page 28.
No, my lady, that is where you've got to take great care.
Well, indeed,
Charges dividends of capital profits, but it does not charge dividends of share premium. In other words, the amount contributed for the share which is then returned. The only way it does is because there are rather complicated provisions in the part 23 which deal with whether or not something is a return of capital.
I really don't want it to think we should get into this in detail, Mr. Gammy, but if I could just draw your attention to the authorities bundle at page 28, it draws a clear distinction between dividends and other distributions, and it's only in relation to those other types of distributions that you carve out amounts that represent repayments of capital or new consideration received, which I think are the provisions that you have in mind. But I think this just illustrates the danger of looking at those other provisions, which I didn't think was going to be the basis of this appeal. It's not in the skeleton argument.
My lady, we're obviously looking at the explanatory notes. I obviously rely upon the wording of the legislation and the wording and how Jersey law treats share premium. But insofar as Parliament is being told something here, as we see from First Nationwide, what is a capital profits dividend is why it refers to in part 6 as it was and part 23 now, dividends including dividends of capital, in other words, capital profits. I mean, one would have to trace, when I say to trace the history, as I say, before dividends, sorry, let me just step back for a second. When dividends were distributable when share premium was distributable as dividends, it was not taxed as income. Of course, that's pre-1948. Is that from a UK resident company? That was because it did not come from a fund that had borne income tax. It had come from capital. And that's clear from other cases in the, so both Bates and Hill, two cases in the authorities, the company said, we're paying these dividends from capital profits. And the reason, and as is clear, that was because capital profits dividends were not taxed at a time when share premium could be paid as a dividend, or when capital profit, sorry. At that time, share premium was exactly the same as capital profit, so it was taxed in exactly the same way, or rather not taxed to income tax. From 1948, you're in a world where you can't pay a dividend of share premium. So when in 1965, Schedule F is introduced and a distribution has to be defined, it is, of course, the background to that a dividend cannot be paid out of share premium. It can only be a distribution in its wider sense. And a distribution of share premium is specifically taken out of charge as a distribution, because the share premium is a return of the capital that the shareholder has contributed to the company on the issue of its shares. Now you have to ask yourself the question, if you're dealing with a system of law which allows share premium to be returned in the form of a dividend, does that dividend have a capital nature because it represents the value that the shareholder has contributed on the issue of his share? That's the fundamental question.
Can you situate that in this case and Mr. Beard's situation? What did he contribute?
The way in which Glencore was incorporated or listed is described in the agreed statement of facts. Effectively, he was a shareholder or had, if you like, a shareholding interest in the original Glencore that was being listed. And the shares he received represented the value of his interest in the Glencore pre-listing entity that were issued to him when it was listed and floated on the London and other stock exchanges.
Yes, so his capital contribution was his existing shares.
Yes, his existing interest in the underlying Glencore entity that was being listed, yes. I mean, and I'll say so, if he had sold his interest in the Glencore business that he held before listing for debt, and that debt was then repaid in installments by the company that had bought it, nobody would begin to suggest that those were income receipts. Here, he received as payment for his interest in the business shares in the new entity, and he was repaid part of the capital that he'd contributed by instalments over a number of years. That's what the company was doing. It was effectively paying for its business, using the share premium that had been created on the issue of its shares to return that value to the Glencore shareholders over a period, which was why, no doubt, the Swiss Revenue Authority were quite happy to agree that the amounts being paid were not income dividends, they were not part of the earnings and profits, but they were part of the original contributed capital for the shares that it had issued, on the shares that it had issued. It's a finding of fact, it's agreed fact, that what happened was that as these Glencore distributions were paid, the amount credited to the share premium account was debited and reduced, and the retained earnings and profits remained in the company. No part of that payment came from the retained earnings and profits. So say if we were talking about he'd sold part of the business for an element for a loan, and he was being repaid part of the capital on the loan, nobody would begin to say that what he was receiving was an income receipt.
Do we go on now to the local law? We're at the explanatory notes, and I note at paragraph 192 of those, which is dealing directly with subsection 4 of section 402. It says we have to analyse the payment under the local law. I think we're all on that page.
Indeed.
So is the next thing to do to turn to the analysis of the Jersey law?
Indeed, my lady, I'm more than happy to do that. I mean, the only point on 192 that no doubt my own friend will want to make is that it refers to corpus. As I say, nobody's saying that in deciding whether or not something is or is not of a capital nature that you should necessarily ignore corpus. I just say it's not a determinative criterion. In relation to how foreign law plays on some of these, one authority I might just take you to is what Mr. Justice Robert Walker said, as he then was, in a case called Memek. It's in the authorities bundle at page 511. And you'll see it's the section at the bottom of the page that is highlighted. He said, when an English tribunal has to apply of a United Kingdom taxing statute to some transaction, arrangement or entity which is governed by a foreign system of law, the tribunal must take account of the rules of the foreign system, properly proved if not admitted, in order to determine the nature and characteristics of the transaction, arrangement or entity. Having informed itself of the characteristics of the transaction, arrangement or entity, having informed itself in this way, the tribunal must then apply the taxing statute as part of English law. The point is made several times in the speeches of the House of Lords in Ray and Lazard Investment, which of course we also have in the bundle. Lord Pearce, he says, put it concisely, the factual situation which includes foreign law has to be examined in order to apply English law. He then referred to what Justice Rowlatt said in Garland and Archer Shee. The question of the American law is, what are exactly the rights and duties of the parties under an American trust? But when you find what those rights and duties are, you see what category they come in and the place they fill in the scheme of the English Income Tax Acts, which the courts here must construe. So, my lady, that I think is a fairly concise statement of the position. So, just before I turn to the Jersey law, which I'm going to take you through, there is a case, it's not in the bundle, but I should probably just draw your attention to it. a case by the Supreme Court last year called Centrica Overseas Holdings Limited versus HMRC. The reference is 2024, One Weekly Law Reports 3391. It's a UK Supreme Court decision 25 of 2024. And that was concerned with whether or not something is of a capital nature. And in Centrica, the question was whether certain management expenses were of a capital nature or were deductible as revenue expenditure. So it's not directly in point in dealing with expenditure rather than here income in the form of dividends and whether dividends are of a capital nature. But as the Supreme Court made clear in Centrica, the question whether or not something is of a capital nature is a question of law. It's a question that falls to be decided in the case of expenditure by reference to the principles so far as they can be identified from the many authorities on the subject. And of course, the tax cases are absolutely littered with cases as to whether or not expenditure is or is not capital or revenue expenditure. And then the application of those principles to the facts of the case.
Do you have copies of that?
My lady, I don't, but we can certainly produce copies. As I said, one reason why it's not in the bundle, if you read the section of the Supreme Court decision, sort of trying to identify what are the principles as to whether expenditure is of a capital nature, it doesn't. When I say it doesn't really advance the situation here, because here, as we've just seen from what Robert Walker J said in Memic and referring to Ray and Lazard's, we're concerned with how the foreign law deals with the matter, which is the relevant, but I say the relevant thing. So, but I say at least the Supreme Court tells us in Centrica that whether or not the dividends are of a capital nature is a question of law, and it means identifying the relevant principles as to whether a dividend, which of course is ordinarily an income receipt. I mean, dividends are the archetypal form of income, but the question is a dividend of share premium from a Jersey company of a capital nature? Of course, in Centrica, the Supreme Court was also dealing with unchanged law, a long line of authorities stretching back over many years, whereas as we can see here, we have relatively few authorities, when I say none of which are especially helpful. I mean, in the case of Ray and Lazard's and Courtauld, you're dealing with cases where, as I say, neither of them involved a dividend, so it didn't actually have to answer the question, is it of a dividend nature? First Nationwide, on the other hand, did deal with a dividend, but as I will show you, Cayman law is different from the Jersey law. So in the present case, we have novel statutory language, to try and put that in neutral terms. Novel, it's certainly novel language, even if it doesn't have, I'll then argue about what the effect of it is. And we're dealing with a company law that allows the return of share premium to shareholders that differs in material respects from that considered in previous authorities. And I say that because all of the previous authorities, of course, are dealing with systems of company law which have imposed the maintenance of capital principle. In other words, say you cannot pay a dividend out of capital. So in that sense, they are not directly relevant because they never actually had to address the question of how the dividend is taxed. And as I said, if you're looking at a UK resident company before 1948, a dividend of share premium was not taxed as income. And it's not taxed as income after 1948 when it's returned otherwise than as a dividend on the basis that it can't be paid as a dividend. And I say the statutory question here, is it a dividend of a capital nature, can be answered by reference to the 3 R's, not reading, writing, arithmetic, but received, recorded, and returned. So we have to look at how it's received, how it's recorded, and then the manner of return. Now, as a matter of general principle, the value with which we're concerned was received by Glencore, I say, as capital. I mean, I do not know on what basis one would ever conclude that on a initial public offering, an IPO, where broadly speaking the existing owners of the entity sell it to a new entity which is going to be listed on a public exchange and receive shares representing the value of their business, which is then credited as capital in the share premium and the nominal account of the company. I do not know on what basis you would conclude that was not a capital transaction or of a capital nature. If my learned friend can suggest an answer to that, I'll deal with it in reply, but I certainly cannot on any basis understand how this was not received by Glencore as capital. If you're talking about, we're talking about what is the nature of it. It was capital in nature. Then the question is, was the value that Glencore gave at all times recorded as capital in Glencore's accounts, in particular its balance sheet? And to see that, we need to look at the Jersey Companies Law as amended initially in 2002 by Amendment number 6. Now, the relevant provisions of the Jersey Company Law are in the authorities bundle and are at tabs 10 through to 16, because of course there were a variety of amendments, which is what gives rise to this particular dispute.
Sky, can I just ask you, for my own curiosity, I'm sure that the 3 R's test is hallowed and comes from somewhere. What is the origin of that?
The origins of that are my suspicions, my lord, in the sense that I don't think there is any case where they've been articulated in that way. But what we're looking at, what the Supreme Court tells us is that this is a matter of identifying the principles. And I say one of the things to do is to look at all the facts that surround the return of this share premium by Glencore to its shareholders, to see if we can identify where something is treated not as capital but as income. In other words, if what you're looking at from a Jersey company law perspective is something that is capital.
Yes, I think you've answered my question as to
Yes.
the provenance of this point. Was the 3 R's submission made below?
It was not put in those terms, but essentially, I mean, I don't think I articulated 3 R's to the Upper Tribunal or the First Tier Tribunal, but I mean, all the arguments that I'm making are essentially, I just tried
You've packaged it in that way for us.
Indeed, my lord, I've tried to package it in an attractive way that might at least strike a note with you, my lord.
Thank you very much. Right, you're going to Jersey.
Yes, in Jersey. So we need to start at page 71 in the authorities bundle, where we see the Jersey Law 1991. This is as it was enacted And as the Jersey law experts agree, it's in their joint agreed memorandum at paragraph 1.2 in the supplemental bundle at page 206 for your note. The original drafting of the 1991 law owed much to the UK's Companies Act 1985. And in particular, if we look at page 80 in the authorities bundle, we see Article 39 of the 1991 law, which deals with share premiums, and broadly speaking, in much the same way as the Companies Act 1985 and other UK companies law provided, this required that if a company lots shares at a premium, whether for cash or otherwise, that must be credited to a share premium account, and the share premium account, we're told by subsection 3, it says that subject to this article, the provisions of this law relating to the reduction of company share capital apply as if the share premium account were part of its paid up share capital. So share premium under the original 1991 Act, Article 39, is being treated as paid up share capital, and at page 88, we see Article 61, which one says, subject to confirmation by the court, a company may by special resolution reduce its share capital in any way. So broadly speaking, the provisions of the original 1991 Act are very much the same as the UK Companies Act 1985. And of course, share capital in this context includes both the nominal share capital and the share premium, which is treated as paid up share capital. And at 8 pages, we can see that exactly the same similar provisions apply to a capital redemption reserve. If one looks at page 82 of the bundle, just going back to Article 55.
I couldn't see it spelled out, but I'm assuming that capital redemption reserve, as in a UK company, arises in particular on the redemption or purchase of shares.
Yes, indeed. So on redemption, which is in part, so you've, as we'll see when we get to it, you've got effectively 3 parts of the Jersey company law. Part 11, which deals with redemptions and repurchases, part 12, which deals with reductions of capital, and part 17, which deals with distributions, as they call it, which is effectively a distribution, which we can see if we look on page 94. We're still looking at the original, the Act as originally enacted. Article 114. And broadly speaking, if you actually turn on to page 95, you can see that the way in which distribution is defined, it's every description of distribution of a company's assets to its members in their character as members, whether in cash or otherwise, except distributions by way of, and that then you've got redemption or purchase of the shares, a reduction of share capital by extinguishing the liability of any of the members on any of the company's shares in respect of share capital not paid up, etc. So broadly speaking, anything's a distribution other than what's excluded. But if you go back to page 95, I think it is,
We're on page 95.
94. You'll note that there is a difference here to the English provision in that a company, this is Article 114.3, a company may, with the sanction of a special resolution, make a distribution out of unrealised profits, less its losses, whether realised or unrealised, provided the directors reasonably believe that immediately after the distribution has been made, the company will be able to discharge its liabilities as they fall due, and the value of the company's assets will not be less than the aggregate of its liabilities, and then over the page, the nominal amount of its issued shares, any amount standing to the credit of its share premium, and any amount standing to the credit of its capital redemption reserve. So broadly speaking, under the original Act, share premium is treated as share capital, part of the share capital, and the only way it can be returned is by way of a reduction under Article 61 of the Act. So that's how they start off.
Could I just understand what your targets are when we're considering Jersey law? What is it that you're seeking to persuade us of? Is this informative for your wider submission, or are you aiming at the first tier's findings?
At this stage,
or both?
well, my lord, sorry, I should perhaps have just outlined. At this stage, I'm setting out why I say these are dividends of a capital nature. I was then, having explained that,
Yes.
I was going to explain why both the First Tier and the Upper Tribunal reached the wrong conclusion, because I thought it was easier to do that in the context of having explained
I'm
to
only
you.
wanting to check that
Yes.
this is part of your submission in relation to capital nature,
Indeed.
which will involve and may need to involve disturbing the conclusion reached by the first tier judge in that respect.
Indeed, my lord.
Thank you. That's all I need to do. Good answer.
So we can see, as I say, in the original Act, share premium is part of the share capital and can only be returned by way of a reduction of capital under Article 61. It can't be returned under as a distribution, because although a distribution covers every description of distribution, it can't include share premium or share capital. So that's the situation in 1991. Now we need to turn on then to what happened in 2002, because in 2002, Jersey company law departed significantly in a variety of ways from the previous position, and indeed the position under English company law. So amendment number 6 of 2002 starts at page 97. And the first thing to note is that it introduces a variety of new definitions or new types of company. So we can see on page 98, for example, that it's talking about a limited life company, private company, etc. But the one I want to focus on particularly is on page 100, where we see that there is inserted a definition of capital accounts. So capital accounts means, in relation to a par value company, it's share capital accounts and any share premium accounts and capital redemption reserves. And B, in relation to a no par value company, it's stated capital accounts and any capital redemption reserves. And just
Is this amendment that it also introduces no par value companies? isn't it?
indeed, my lady, this is a significant departure from the English situation, because it now contemplates that you can have a no par value company and no par value shares. And of course, I mean, one can observe that the Glencore shares are about as close as you can get to a no par value, and not having a no par value because it's only a 1 cent share. So I mean, obviously, it's still a par value company, but its shares are only, well, one should note, its only shares are only 1 cent shares. Just to note the definition under capital accounts, it says cause has the meaning assigned to it by the customary law of the island. That's essentially cause is there for how they call consideration. I'm not going to go into the intricacies of what the difference is between English law consideration and Jersey law cause, but broadly speaking, that's how you can think about it. And that will become, we'll see that expression used when we get to no par value companies. Turning on, we can see the definition on page 102 of a par value company and a no par value company, which is
No
much
par
as,
value company is 101.
is a share which is expressed as having a nominal value. No, well, it's a par value company is defined in 3E.
Yep.
Yeah. A par value shares expressed as having a nominal value, and if we just turn on, so that they're the sort of definitions that are inserted to allow for the fact that you'll now have a no par value company. If we go on to page 108, Article 3 now tells you about the method of formation. And if you look on 109 in particular, it tells you right at the end of Article 3 that a company, or public or private company, may be formed as a par value company, no par value company, or a guarantee company, but shall not have a share capital, the shares of which include par value shares and no par value shares. In other words, you can't have a mixed company, some of which are par value and some of which are not. And then the actual definition of a par value company is at Article 3E, which is on page 110. And these are all much as you would expect in using one's own sort of intuition about what it would be. So a par value company is registered with share capital and its shares are expressed as having a nominal value. And on the following page, Article 3F tells us that a no par value company is registered with shares which are not expressed as having a nominal value. And then if we go on to new Article 4A, Article 4 on page 112 tells us that what the Memorandum of Association must include, but at 4A, it's dealing with the Memorandum of Company with shares. So where a company is to be registered with shares, if it's a par value company, the memorandum shall state the amount of share capital with which it is to be registered, and the amounts being fixed amounts into which the shares of each class are divided. That is significant, as Mr. Felton, the expert for the taxpayer, explained at the First Tier Tribunal, because the memorandum requires that for a par value company, the amounts with which the shares of each class are divided, you can't make a distribution under Part 17 or in respect of the nominal amount, or you couldn't in the relevant time when this was introduced, because inevitably that would involve a change in the memorandum of association. So you'd have to proceed in a way which allowed the memorandum of association to be amended to deal with the fact that you were returning part of the nominal amount on the share, and that therefore they were going to change in the amount in which they were divided. That is why, as we'll see when we come to it, you can debit a distribution to a stated capital account of a no par value company or share premium, but you can't debit it to nominal par value because that would necessitate a change in the memorandum. That at least is one reason, one explanation for a subsequent change that is made. And we see that if, again on page 113, if it is a no par value company, the memorandum shall state the limit on the number of shares of each class which the company is to be authorised to issue. So there's no problem about debiting the stated capital account of a no par value company because it doesn't involve any change in the memorandum of association. I hope these points will become clearer as we go through to explain why the legislation says what it does. So that's Article 4A. And note about this as well, that it's very specific about dealing with each class of share. In other words, you don't just have, as we'll see, an aggregate share premium account or an aggregate stated capital account of a no par value company. The amount that's contributed by way of share premium or by way of cause, i.e. consideration for a no par value share, is specifically attached to the class of share that is being issued.
You'll show us that, will you?
Indeed. We'll get to that in a second. If we go to page 130 of the bundle, we can see in Article 20, the amending, for Article 39 of the Principal Law, that was the one dealing with share premium account and the requirement to create share premium account. The following articles are substituted. One might also note, just on that page above that in relation to Article 38. Article 38, we can see the heading was originally for the word share capital. There shall be substituted the words capital of par value companies.
Sorry, I've missed where you're reading from. Is this an Article 19?
It's Article 19 at the top of page 130, my lady. And the rest of it is, I think, all largely to do with currency changes. So they deal with cases where the nominal value of shares is expressed in one currency, but then is converted to another currency. So I don't think I'm going to take you into...
But you're relying on the change, or drawing our attention at least to the change of label in 19.1.
Indeed, I'm just drawing your attention to the fact that they're consistent with the changes that are being made throughout. Where it's previously referred to share capital, it's now going to refer to capital of a par value company or stated capital account of a no par value company, or if it's talking about all of them, it can refer just to capital accounts. It doesn't have to refer to capital accounts all the time because the capital accounts we know comprise the stated capital count of a no par value company, the capital redemption reserves, the share premium, and the nominal value of a par value share. So we see at the, as I said at the bottom of that page, that Article 39 is being replaced by a number of articles, and in particular, Article 38A is dealing with the alteration of capital of no par value companies. So it tells you under Article 38A what you can do to change the capital of a no par value company. Article 38B deals with the rate of exchange for currency conversions. I don't think we're concerned with that. And then Article 39 is a replacement for the previous Article 39, which dealt with share premium accounts for par value companies. And as we can see, that tells you at Article 39(1), if a par value company allots shares at a premium, whether for cash or otherwise, where the premiums arise as a result of the issues of a class of limited shares, a sum equal to the aggregate amount or value of those premiums shall be transferred as and when the premiums are paid to a share premium account for that class. And where the premiums arise as a result of the issue of a class of unlimited shares, a sum equal to the aggregate amount of value of those premiums shall be transferred as and when those premiums are paid up to a separate share premium account for that class. And it tells you about how the share premium account can be expressed and what it can be applied for in 3. And then Article 39(4) is what was previously in Article 39(3). Subject to this article, the provisions of this law relating to reductions of a par value company's share capital apply as if each of its share premium accounts were part of its paid up share capital. And then we see the corresponding provision for no par value companies in relation to stated capital accounts, which again tells us that every no par value company shall maintain a separate account to be called a stated capital account for each class of issued share. And you're told at 3, there shall be transferred to the stated capital account for the class of share concerned the amount of cash received by the company for the issue of shares of that class and the value as determined by the directors of the cause received by the company otherwise than in cash for the issue of shares of that class. So it's quite clear that both in relation to par value companies and no par value companies, if you create separate classes, the share premium in the case of a par value company or the stated capital account in the case of a no par value company is attached specifically to the class of share in respect of which the value was given. It's notable, when I say notable, I would just draw your attention to the fact that in the case of share premium, as we saw in the original Article 39, as introduced in 1991, and as we now see in the new Article 39(4), the premium is treated as paid up share capital. There is no equivalent provision to treat the stated capital account of a no par value company as paid up share capital. The stated capital account is the no par value company's share capital. So broadly speaking, these are all comprised within the capital accounts of the company. And basically speaking, as I'll show you in a second, when I come on to the conversion of one into the other, the aggregate of the nominal par value plus share premium of a par value company is its capital, and the stated capital account of a no par value is its capital, and broadly the two should be equal. So if for 6 billion, which was, I know, however much Glencore was worth, it is with 1 cent shares, it creates however many 1 cent shares plus share premium, which equals 6 billion. If it were a no par value company, it would have a stated capital account of 6 billion. I mean, the two are one and the same thing in terms of what is part of the capital accounts and what's recognised as the capital accounts of the particular company, according to whether it's par value or a no par value company. And we see that when we get to new articles 40A and 40B. 40A is at page 135, and you'll see that this is dealing with the conversion of shares in par value companies. So a par value company may convert its shares into no par value shares by altering its memorandum in accordance with this article. And you'll see under 2A, Article 40A 2A, that the power conferred by paragraph 1 may only be exercised by converting all of the company's shares into no par value shares. And we'll see when you go, if you can think back to Article 3 dealing with formation of par value or no par value companies, it said that a company can't have shares which are both par value and no par value. So that's obviously the explanation why you can't set up a par value company and then convert part of its shares into no par value shares. And then we can just see the subsequent paragraphs of 40A tell you how you achieve that by the conversion by special resolution, which has to be special resolution by a meeting of holders of each of the classes of the shares. So each class has a separate say about this because their shares are obviously going to be converted from par value to no par value shares. And then over the page at 136, we see a paragraph of sub-article 4. Upon converting its shares under this article, the company shall transfer from the share capital account of each class of shares to the stated capital account of that class, the total amount that's been paid up on the shares of that class, and shall transfer any amount standing to the credit of the share premium account or capital redemption verve to the stated capital account for the class of share, which would have fallen to be issued if that amount had been applied in paying up unissued shares allotted to members as fully paid bonus shares. In other words, you've got a class of share, let's call them A shares, for which you contributed premium of $1 million. So you've got a share premium account for the Class A shares of $1 million. You would be entitled to issue or capitalise or whatever, to pay up unissued shares as fully paid bonus shares, assuming it's 1 unit per pound, 1 million A-class shares. That gets transferred to the stated capital account, in other words, the capital account of what is now a no par value company. I mean, all of that, I hope, seems relatively logical and unexceptional, exactly as you would expect, given that premium is attributable to each class of share in respect of which it's been paid and is recorded in the company's accounts, in its balance sheet, as being share premium attributable to that class. And then going on, we see Article 40B conversion of shares in no par value companies, and no par value company may convert its shares into par value shares by altering its memorandum in accordance with this article. And again, we see at 2A, the power may only be exercised by converting all of the company's shares into par value shares. And we're told, if we go on, that for the purposes of conversion, this is on page 137, Article 40B3. For the purposes of a conversion of shares under this article, each share of a class shall be converted into a share which confers upon the holder as nearly as possible the same rights as were conferred by it before the conversion, and has a nominal value specified in the special resolution of the company, being a value not exceeding the amount standing to the credit of the stated capital account for the class divided by the number of shares of that class in issue, all done on a class-by-class basis. And then you're told in 5 that upon converting its shares under this article, to the extent, this is 5A, to the extent that the amount standing to the credit of the stated capital account for each class of shares equals the total nominal amount of the shares of that class into which those shares are converted, transfer the amount to the share capital account, and shall, to the extent, if any, that the amount exceeds the total amount, nominal amount, transfer it to a share premium account for that class. So it's precisely as you'd expect it to operate. You've got a no par value company with 6 billion in the stated capital account. It now wants to become a par value company, issue par value shares of 1 cent. So it's going to transfer that stated capital account 1 cent to the stated to the nominal account of par value, and the rest to share premium, exactly as you'd expect, just as on the other way round, share premium gets into the stated capital account. And I simply say that that tells you, certainly in 2002, that all of these amounts in the stated capital accounts of the companies, whether they be par value companies or no par value companies under the Jersey Act, are being regarded as part of the capital of the company. And that I say that is I say obvious. I mean, I hope there is nothing particularly unexceptional in that particular view of how the share premium or the stated capital amount of a no par value company, etc., are being treated for these purposes. The rest of other changes by 2002 to allow for the introduction, again, as you might expect. So if we go on to page 143 in the authorities bundle, there's an article there, Article 52, variation of class rights, which we're told do not apply in respect of a conversion of shares in accordance with Article 40A or 40B, well, because 40A and 40B provide their own procedure to deal with how the classes are dealt with. And then on page 147, we can see under the new Article 55, power to issue redeemable shares. There's again a substitution. Again, it's all dealing with payment of so at the bottom of page 148, payment of any premium on redemption out of the share premium account for shares of the class concerned. So if you're going to redeem, you've got to redeem out of the share premium for the class concerned. Again, these are, as you'd expect, the premium tied to the particular class of shares which you're dealing.
Sorry, which subparagraph are you referring
Sorry,
to?
that was sorry, my lady, that was at the bottom of page 148, I think. It's right at, is it right at the bottom?
I see.
Yes, it goes 148 to 149, it goes over. And then there's new provisions, and again, when I say new provisions for purchase of own shares, sorry, on page 100 and, sorry, my apologies, let me just get the right article here. Yes, actually, sorry, Article 55, the power of redeem, is quite a long one, so it goes over several pages. I'm just finding the right.
Own share purchase is new Article 57, page 152.
Yes, that's right. The creation of, in the case of a redemption, the creation of the capital redemption reserve is dealt with on page 150, and at the bottom you see provisions of Article 61 applies if the capital redemption reserve were paid up share capital. So similar to the provision in Article 39. And yes, Article 57 is on page 152, and that applies the provisions, the redemption provisions. So I think the next one, just to note, is on page 156. Where the Article 61, which was previously, of course, stated to be, it was originally headed Special Resolution for Reduction of Share Capital, is now headed Reduction of Capital Accounts. So a company may by special resolution reduce its capital accounts in any way. And at this stage, in 2002, it still provides that every reduction shall be subject to confirmation by the court. And we're told at the bottom of 156, a reduction of capital by reducing a share capital account or stated account, which is either established in respective limited shares, shall not be subject to confirmation by the court in certain cases. I don't think
that's not applicable.
Yes, no, I don't think we need to be concerned. And we see again in Article 40, amending Articles 62 and so on, it's substituting capital account for the word share capital, and so on. If we turn on to page 180, we see Article 70 is amending Article 114. This was the provision under which distributions could be made. So previously, as we saw, that a distribution could be made from unrealised profits so long as the directors were satisfied that it could discharge its liabilities and the value of its assets wouldn't be less than the aggregate of its liabilities and the nominal amount of its issued share premium and capital redemption reserve. And of course, as you'd expect, this is amended just to substitute, as you see in Article 72, the B, it's the amount standing to the credit of its capital accounts. So throughout the Act, having taken the decision, the legislature to introduce no par value companies as well as a variety of other changes, I'd suggest that the only possible conclusion you can reach is that the capital account represented by the share premium contributed on the issue of any par value share and attaching to that particular class of share is recorded as and represents part of the company's capital. The nominal value and share premium of par value share correspond to the stated capital account of a no par value share, in each case on a class by class basis, so that under the 1991 Act, following the 2002 amendments, share premium is as much part of the capital of a par value company as is the stated capital account of a no par value company. That's what I say is the situation as it exists in 2002 and subsequent years, until we get, when I say until we get to amendment number 9, which was made in 2008. So up to 2008, I would say, if we go back to my 3 R's, as I said, I can only think that this was value received by Glencore as representing capital, and it was recorded in its accounts as capital. Of course, Glencore at this stage didn't exist, but what we're looking at is how a company would be treated. And then, or rather, Glencore didn't exist in this form. It probably existed, but not in this form. So the question that arises, is there anything to disturb that conclusion? In other words, that share premium is treated as part of the capital of a Jersey company by the introduction of Amendment number 9 in 2008. Now, Amendment number 9 substantially limited, although didn't completely abolish, the original doctrine of maintenance of capital and the requirement that distributions could only be made from a profit and loss account or unrealized revenue profits. So let me put my point this way. If as a legislature you choose to move away from the maintenance of capital principle for protecting creditors and adopt instead a solvency statement mechanism, is a necessary consequence of that choice that you always regard, what you always regarded as capital is no longer capital. Or does what was always regarded as capital remain capital, but it's just that its return to shareholders no longer attracts the particular creditor protection previously envisaged by the maintenance of capital principle? That's the essential question, because broadly speaking, what the revenues say and what the tribunals decided was that all of a sudden what Jersey law had always recognised as capital of a company, both the equivalence of the par value and share premium plus an NPV capital of a no par value company, I say, is apparent from the way the Act works. That's always been regarded as capital. And then the legislature says, instead of having the old rule derived from Trevor and Whitworth, that you cannot pay a dividend of capital, we are going to have a solvency declaration by the directors as to whether this payment can be made. Does that change the character of what was regarded as capital to something that is not capital, just because now Jersey company law allows something that can be described as a dividend to be paid from its capital? It's my submission that there's no reason why the legislature should not allow a company to return what it recognises as capital in the form of a dividend. Why should it not? It's always recognised these amounts as capital. They're part of the capital accounts. Broadly speaking, these amounts do not remain within the capital accounts of the company. They remain returnable by way of a what has been called in some places a formal reduction of capital. In other words, a reduction of capital under Article 61. But because the legislature says we will protect creditors in a particular way by way of a solvency statement rather than by preventing the company returning its capital to shareholders as a dividend, that somehow completely alters the character of what the shareholders get back, when what they get back is what they contributed on day one as the consideration given for their shares, and what has always been and continues to be recorded in the company's balance sheet as part of their capital. In other words, the liability that the company owes to them in respect of the shares that they acquired for this value. Now, what was done in 2008
Is this a moment? You're about to
Sorry,
embark on.
I had not kept my eye on the clock. Yes, we could, because I'm going to now just go through, explain what happened
Yes.
in 2008.
How have you decided to divide up the time between you?
My lord, I had assumed I would conclude today.
Very well.
Um,
Thank you. 2 o'clock.
Court rise at table.